Welcome to COVID Conversations with Lawyers. I'm Brian, and with me is Ignatius. In this webinar, we'll be examining how the COVID-19 pandemic has affected the practice of criminal law, what the far-reaching implications are on society, as well as the potential effects the pandemic may have on access to justice. For this Conversations with Lawyers, we have the privilege of having with us Ms. Shazana Yaha. Ms. Shazana is a partner at the firm Eugene Thuraisingham LLP. She graduated from the National University of Singapore in 2015 and was subsequently called to the bar in 2016. Ms. Shazana is no stranger to the realm of criminal practice. Having litigated cases in the Court of Appeal, Ms. Shazana has achieved notable results in criminal advocacy for clients charged with serious crimes, such as murder, rape, and drug trafficking. Some of these cases have gone on to serve as legal precedents for future cases. Ms. Shazana is also a strong advocate of pro bono work and regularly takes up appointments with the Criminal Legal Aid Scheme, also known as CLAS, and the Legal Assistance Scheme for Capital Offences, also known as LASCO. Outside of law, Ms. Shazana is a passionate champion for social causes involving gender equality and the interests of minority groups. Ms. Shazana, welcome.
Thank you. Thank you for that kind introduction. Hi, everyone.
Okay, so to get things started, Ms. Shazana, could you give us an overview of the criminal justice system in Singapore and the roles that both the prosecution and defense lawyers play respectively?
Okay, sure. So the role of the criminal justice system in Singapore is on one hand to protect society from crime and to uphold law and order. And then on the other hand, it's to ensure that the due process is observed as we investigate, try, and sentence accused persons. The various actors at play, people who play a part in making sure the criminal justice system functions effectively include the prosecution, the defense, and obviously the court. So I'll start with the role or function of the public prosecutor. Their role essentially is to prosecute persons or entities in court by bringing the evidence to court. So in criminal law, the starting point is that the accused person is innocent. So when the prosecution comes to court, their job is to displace that presumption of innocence by proving their case beyond a reasonable doubt. In recent cases, courts have described prosecutors as ministers of justice. So when they come to court, their job is to achieve justice. It's not just to convict or to win at all costs. Moving on then to the role of defense counsels. So there's a very common misconception that our role is to help bad guys get away. That's not my job. Our job really is to make sure that the criminal justice system punishes only those who are guilty and that innocent persons are not unfairly caught by the system. And if they are punished, then it's our job to make sure that the punishment is for the correct offense and the sentence is appropriate. So I think that would summarize the roles of the prosecution and the defense and how they play a part in ensuring the effectiveness of the criminal justice system.
Shazana, so since you already have told us about the role of defense lawyers, what is the court guided by when sentencing an accused person after they have been convicted?
Okay, so there are 4 sentencing objectives when it comes that the court takes into consideration. Certain sentencing objectives will take precedence depending on the nature or the circumstances of the offense. So the 4 sentencing objectives are retribution, deterrence, prevention, and rehabilitation. And depending on the nature of the offenses, different objectives will take precedence. So for example, if the offense is something that is serious and there is a strong public interest in mandating a severe sentence, general deterrence will take precedence. If you have, say, a young offender, first-time offender, rehabilitation will take precedence. So these are some of the considerations that the court will take into account when sentencing an offender.
Thank you, Ms. Shazana. So what do you think the court takes into account when sentencing for these current COVID-related crimes?
Certainly, deterrence is it's probably the sentencing objective that will take precedence because where an offender commits a COVID-related crime, the general interest is in preventing other people from committing similar offences. And there's also the element of specific deterrence, which is to prevent that offender from re-offending. So when it comes to COVID-related crimes, generally, deterrence will take precedence. But when we have a young offender in the picture, so for example, the case of the teenagers who sampled juice boxes in NTUC and put it back, and then the other guy recorded the incident and put it up online. So that case involved two young offenders who committed a COVID-related offense, but they were sentenced to probation. And the reason why they were sentenced to probation was because they're young, and rehabilitation in that case took precedence. So different considerations will come into play when we look at the circumstances of the case.
Thanks for that overview, Ms. Shazana. Perhaps you could share your thoughts on how the changes brought about by the coronavirus pandemic has affected your practice, particularly in criminal law. For instance, with the moving of trials online and how that might have affected your ability to practice, as particularly criminal law.
Sure. So frankly, it's a game changer, okay? It has drastically affected and changed the way we practice, and I think it's for the better. What I'll do is I'll touch on some aspects of criminal practice which has changed since the pandemic. First, pre-trial conferences. Pre-COVID, defense counsels used to have to wait 2 to 3 hours for a PTC. And things are a lot more efficient now that the hearings are conducted virtually. We can do our work online while waiting for a PTC. The next area is adjournments, and I think this is a very good development. State courts are now allowing online applications for adjournments via the ICMS system. So back then, we used to have to physically attend court, wait to be called, just to ask for a routine adjournment. And now it's so much faster because all you have to do is put up the application on ICMS, and then the adjournment is granted shortly after, provided, of course, your request is valid. Another area is plead guilty hearings and appeal hearings. All these are conducted virtually now. Accused persons will be in court. They will appear by Zoom. Us lawyers will appear virtually, will make our arguments. It has created a bit of difficulty because previously when hearings are conducted physically, it was open to us lawyers to just turn to our clients and seek instructions on the spot if necessary. But now that we are in separate locations, when the hearings are conducted virtually, that option is no longer open to us. But of course, it's not an insurmountable difficulty. The court can still allow a stand down to take instructions. Another area is trials. Trials are still conducted physically most of the time. I suppose it's because it is important for the court to examine witnesses' demeanor when giving evidence. But Section 28 of the COVID-19 Temporary Measures Act allows for an accused person or witness to give evidence by video, and this is typically used for witnesses who are overseas. And the last area I'd like to touch on is passing sentences. Recently, courts have been delivering their verdict online as well. And this has given rise to a rather interesting issue. Recently, the Supreme Court passed its first death sentence via Zoom for one person known as Punisan Genasan. And it has been reported worldwide. I did recall seeing an article on an international publication titled Malaysian Man Sentenced to Death via a Zoom Call, and that just didn't look very good. But I mean, some people view it as an affront to human dignity, and that has raised an interesting issue. But I suppose, to be fair, I would also have to highlight, I recall reading that their lawyers didn't object to it. So that's something that has to be taken into consideration in assessing the humanity of this process. But overall, it is a welcome change for us lawyers. A lot of us are very happy with the new system, and I think it will continue for the long run and will be taken even further. Just as a final point, when I say it's going to continue even further, I really want to commend the state courts because they are now piloting a conduct of asynchronous hearings. So previously, parties used to have to, attend court, and each of them will have to make their arguments, and that has led to a lot of scheduling difficulties. So your hearing can be conducted 2 months down the road just because one party is unavailable. But now with this pilot project, the idea is that the parties will provide updates on the progress of their case and seek the appropriate directions by email, and then the court will respond by email with the appropriate directions. So if this takes off, it's going to be another game changer, and I think a lot of lawyers will welcome this change.
Yeah, so actually, I think you raised some very interesting points with regards to the effect on sentencing, which Brian will definitely cover a bit later in the interview. But just to harken back to some of the earlier points that you made about kind of how the move towards legal tech has really had great effect on efficiency and scheduling. And it seems as if, for example, that like a lot of lawyers and I guess the prosecution as well are really able to handle more capacity due to all this new efficiency. I'm just wondering from a private practice standpoint, do you think that this increased efficiency benefits certain firms more than others? I mean, just because, I mean, different firms have different availability of resource, especially in terms of being at the forefront of developing legal tech, for instance. Some firms have dedicated divisions to legal tech, which not all firms are able to dedicate resources to. So I'm just wondering whether that shift has really created some inequity between firms, and particularly what that means for criminal practice, given that a lot of defense work is generally either carried out pro bono or by smaller to mid-sized firms.
Okay. Well, at the moment, I would say the inequities are not so stark. Most of the hearings are conducted by Zoom. Resources, at least for this aspect, is not much of an issue at this stage. But I think you're on to a very important point, because this is the start of a new era. So you're right. Over time, there will be a shift in terms of how we practice, in terms of how firms handle knowledge management, how lawyers do their legal research. And as you pointed out, legal technology is a huge and growing area. So to bridge that potential gap or potential inequity, the Law Society and the Ministry of Law, they have been very supportive in helping the smaller firms and the mid-sized firms enhance their technological capabilities and increase our competitiveness. They are providing funding support for these firms. So I think that is one way the government is helping address that potential gap.
Thanks for that. I think that's a very important aspect, and I think that really sheds some nice perspective on the issue of potential inequity. I think Brian will maybe take over to speak about current inequities or certain things that you already alluded to just now in your answer.
Sure.
Okay, thanks, Ignatius. So, Ms. Shazana, do you think that such changes to the practice of criminal litigation has adversely impacted certain groups of our community more severely than others? For instance, the lower income groups, or maybe those on the fringes of society, like migrant workers or foreign domestic workers. We know, as of the recording, that there's a lot of public interest in the case of Hati Liani and public prosecutor. Although strictly not a COVID-19 related case per se, I think it has raised a lot of questions that require some answers, and they even scheduled parliamentary time to talk about this question. And the Attorney General, they have filed with the Attorney General's chambers to discuss this case. So maybe you could share more about your thoughts on this case.
Sure. So I think I'll just take a step back before I talk about Hati Liani. Well, it's not so much of changes to practice, but generally, when migrant workers face criminal proceedings, the impact is seriously a lot harder. Because life as a migrant accused person is very different and much harder from life as a local accused person. So, I mean, I have a client, she's a foreign domestic worker as well. She's currently waiting for the case to go on appeal. And similar to Pati Liani, because there's an ongoing criminal appeal, she cannot go home, she cannot go to work. The pandemic makes it even harder because now she's worried about how her family is coping overseas with the pandemic. And these are not so developed countries, so the impact of the pandemic there is much harder. And at the same time, she can't work to support her family at the time when the family needs resources the most. And worried about all this while she maintains her innocence. So it is very hard for her. And this is similar to what we hear with the Pati Liani case that you mentioned. So she was, for those who are not so familiar with the facts, she was accused of stealing from her employers. She was convicted at the lower court and then finally acquitted on appeal. It was a 4-year ordeal. And even though she was finally acquitted, at the end of the day, she has not won anything. Because as the criminal proceedings were ongoing, she was unable to work. It's 4 years of her life wasted and 4 years of unnecessary separation with the family. So I think really to sum up my answer to that question, migrant accused persons, they face a disproportionately harder time when dealing with criminal proceedings. And that crack, it widens during a pandemic.
Okay, thank you for that, Ms. Shazana. Just now you touched on about the case of Punithan and public prosecutor, which was the first death sentence passed via Zoom in Singapore. I also like to bring forward the case of Muhammad Azil and public prosecutor, which was the first fully Zoom trial virtual hearing by the Court of Appeal, where a man was that was originally sentenced to death for abetting in drug trafficking was acquitted by the Court of Appeal. Just now you mentioned about the affront to human dignity, and do you think that all these procedural changes like affect the human element or like the right to be present in physically present in your court proceedings?
Okay, so I think when it comes to passing sentences, it's a bit different from the actual Court of Appeal hearing, because the Court of Appeal hearing is mostly an event between lawyers. So just arguments are being canvassed between the lawyers. There's not much input by the accused person himself. And it's really just making arguments. So I think in terms of an appeal hearing, for it to be done remotely, I would say the objection is not as strong. Whereas when in the case of Punithan, passing a death sentence, I can see where the critics are coming from when they say it's not exactly it may not be the best way to do it.
Okay, thank you for that, Ms. Shazana. Another case before the court is the case of Syed Suhail and public prosecutor. So in that case, the defense counsel managed to get a stay of execution at the time of this recording about the argument that there's a differential treatment between foreigners and Singaporeans in carrying out the death sentence of execution, as it's been the execution of foreigners has been halted due to the COVID-19 situation. Can I hear your thoughts on this case, Ms. Shazana?
Okay, so this case is still ongoing. So I would be a bit hesitant on commenting on the case before any decision is out. But I do think that it has raised some very interesting issues. The allegation by Syed Suhail is that the executions of foreigners are being pushed back due to COVID-19. So the allegation by Syed Suhail is that executions of foreigners are being pushed back due to COVID-19. And the reason, and the alleged reason is that if the foreigners are being executed at this time, family can't come to see, and there will be issues with repatriating the remains. The ministry has come out to deny that there is any form of discrimination between foreigners and locals due to the executions. And the Court of Appeal has asked for further submissions on this issue. So it will be interesting to see what happens next, the ministry's response in court on the allegations, and more importantly, if the allegations are true, whether or not there has been a breach of the constitution.
Thank you for that, Ms. Susanna. Maybe I'll hand over the time to Ignatius to talk about more COVID-related offences and the rise of the number of COVID-related prosecutions.
Yeah, thanks, Brian, and thanks, Ms. Susanna, for very interesting insight, especially on cases that are not concluded. I think for sure, I mean, nothing is set in stone, and I guess like all we can do is kind of speculate for the moment. I suppose now we can move on to slightly more backward-looking issues. Definitely, I think with COVID, there have been more COVID-related legislation regulating kind of movement and maintaining order. There have been new criminal offences created in terms of like social gatherings and mandatory mask wearing outside the house. We were hoping to see if we could get some perspective on maybe some of the past COVID-related prosecutions. For instance, some insight about the defences pled or the sentences meted out for some of these cases. And perhaps we could start with one very famous incident that kind of made its rounds on social media with the Robertson Quay incident, where during circuit breaker, several kind of foreign work pass holders were spotted congregating and drinking outside a restaurant. I believe 6 or 7 of them got fined pretty heavily. And I'm just wondering kind of what you thought about that sentence as well as some of the defenses pled. I think a lot of the defenses kind of revolved around the personal impact on all the accused persons, especially the backlash on social media, which I think is another big technological change that's magnified in COVID, especially when everyone's working from home and kind of camping out on social media.
Yeah. So on the actual proceedings, I think if I recall correctly, the prosecution was seeking a jail sentence for a few of these individuals. And that was strongly resisted by defense counsel because it was just not supported by precedent. I think at that time there was only 1 or 2 cases where someone had been jailed for a similar offense. So the defense counsel argued quite strongly against that. But ultimately the sentence was still quite high. I think the fine was somewhere close to 10,000, 9 to 10,000. And that is considered a very high fine. And the reason why that offense was taken so seriously, I think the fact that we were in a pandemic and there was a flagrant breach of the law, that should have been an aggravating factor. Deterrence was definitely one of the key considerations in sentencing. There was at that time a very strong public interest to deter like-minded offenders from doing something similar, and specific deterrence as well. They want to deter these individuals from reoffending. So these were, I think, the considerations that were at play and were the reason for the harsh sentences that were given at the end of the day. On the point on social media, I think the defense counsel, one of the defense counsels also tried to in his mitigation say that these individuals, they were already facing harsh criticism online, and so that the impact, I think the idea is that the impact is doubled, and the judge I don't think the judge took that on as a relevant factor. But I think it is a change because back then it was just when you committed an offense, it was just something that you have to be accountable for in court. But this really signals something a lot larger. When you commit an offense that threatens public order and is of public interest, you're going to be punished on 2 counts, one before the court and one before the court of social media. And I don't know which is worse actually. But this is an interesting, it's interesting development.
Yeah, for sure. I mean, and on top of the cost of social media, they also face kind of like work pass ramifications.
Correct. Yes.
It's
Yes.
probably separate from the cost
Yes.
structure.
Correct. Correct.
And I think something you alluded to perhaps is kind of like the difference in terms of public perception of what comes under the remit of the court. So kind of like capital punishment and fines, as opposed to things like work pass and like mitigating factors such as the punishment in the court of social media, which doesn't really properly come under the court's remit as a mitigating factor.
Mm.
And I'm just wondering kind of like whether that divide in public perception has been magnified. I think as you mentioned earlier with the Pathy Liani case in COVID, where there's been a lot of these kind of correlated prosecutions and perhaps not as much understanding of what properly falls under the court's remit and what doesn't. I think especially with kind of some other cases like where I think there was a woman who sneezed on a security guard in Ion Orchard, who I believe the judge ordered an assessment of whether she was suitable for MTO, but eventually was charged with jail time. And then of course, like there was an incident where some teenagers were shown on video to be sampling juice bottles in like a convenience store, and then they linked it to COVID, and then eventually they got a probation order. So I'm just wondering whether you think that public perception of what properly falls under the court's remit has been adequately addressed in like layman news article reportings of these cases.
Yeah, I think you raised a very good point. I think with this digital age, a lot of people have the tendency to just type without thinking of the consequences. And the information, some of it is good, but some of it might be misinformation. And when you type these things, I mean, it does have an impact on other people's lives. I think that is the government or ministries are working very hard to try and bridge that gap. You see a lot more ministers coming up now to explain certain decisions, why the court decided in a certain way. In Pathy Liani's case, Minister Shanmugam actually came out and commented on the case. I mean, and I think Minister Shanmugam also urged the public not to jump to conclusions too quickly and to wait for the ministry to conduct their own internal assessment of what went wrong. So, I mean, I think this public outcry, to a certain extent, it's good because it holds people who should be accountable, it holds them accountable. But at the same time, I think a lot more needs to be done to inform the public. And the onus, and this, there are two ways to do it. On one hand, there needs to be a lot more communication between MPs and ministers and the public, to educate them on what's going on. But on the other hand, I think netizens also have that personal responsibility to do a bit of verification and checks before they type certain things. So I think if all this is done, we are going to become better as a society, and we can do away with a lot of the undesirable effects of social media at the moment.
Yeah, for sure. I mean, that's very interesting perspective on what can be done. I think, especially with COVID, there's been a lot of magnification of like problems with information dissemination.
Yeah.
And maybe I'll hand over to Brian to...
Oh, okay, sorry. But before we move on, I think one interesting point about the Robertson case, it actually created, the netizens started talking a lot about inequality in terms of treatment between Singaporeans and foreigners. So that created another issue. Whether it's really an issue, I mean, it's something that it caused a lot of self-reflection, which was good. But at the same time, was there a legitimate basis for making some xenophobic allegations? So that is another problem with this divide in terms of public knowledge and disseminating that public knowledge to netizens.
No, for sure. I think that's an extremely interesting point, especially considering that, I guess if you look at these isolated incidences in a vacuum, it's very easy to kind of draw almost false links. Yeah, exactly.
Yes, yes.
I mean, even with the other two examples that we raised with the juice sampling as well as the woman sneezing on security guard, I mean, the teenagers were ultimately given a probation order, whereas the woman who sneezed on security guard was given, I think, 11 weeks in jail, or pretty hefty kind of capital sentence. And it's so easy to just kind of take the easy route and say, oh, it's because she was a foreign national. But I guess like there's so many more considerations, like kind of the sentencing framework, especially with regard given to like the age of the offenders as well. And I'm just wondering if you have any thoughts on how to make that information more easily accessible for for the general public actually.
Yeah. So I mean, I think the problem is that there are certain social issues which are very important right now. Women's rights, xenophobia. These are issues which are hotly debated and the netizens love it. So whenever there are certain things which on the surface looks like, it's unequal treatment, discrimination, gender discrimination, people jump at that without knowing the true facts of the case. So I think one way to bridge that gap is programs like this will help. Lawyers need to come out and do some sort of explaining. MPs, it is the role of the MPs to try and explain what's going on to citizens. But I think citizens are fully capable of finding out and verifying certain things before making their allegations as well. There's Singapore Law Watch, which sets out the details of the judgment. You can always go to the Supreme Court website, the government websites will explain everything. So it's really just a matter of checking and Googling. So the onus is also on us netizens to do those checks before making comments.
Okay, sorry, just to add on to that, what do you think the role of our media or social media has played in affecting the perception of these types of cases? Do you think it adds more fuel to the fire because of the way that the news is about the way that these cases are being reported in the news?
The way, yes. So the way things are being reported in news, it's definitely important. I think how it's being done is that when there is a very high-profile case, the news agencies will report as the trial is ongoing. Now, the problem is that, you see, I earlier said that in criminal law, accused persons who come before the court, they are presumed to be innocent. But the problem is that when people just hear the news, they don't understand this concept of presumption. They don't necessarily understand the concept of presumption of innocence. And so when the prosecution makes the allegation, the tendency is to believe the allegation first and wait for the accused person to prove his innocence. So there is that disconnect between what actually is supposed to happen in court and the public's general understanding of criminal cases and how they work. So social media kind of fuels the public that public perception. Like for example, in the case of Dr. Wee Tiong Boo, when there was the patient who accused this doctor of rape, and for the longest time, people actually believed that he committed the crime, and even after the Court of Appeal acquitted him, there were still people who believed that he committed the crime and got away with it. So that's not necessarily fair to him because there has been an acquittal. And social media has sort of fueled the perception that he's already guilty. But it's a tool, so we can actually change that tool to make it work for us. And at the end of the day, it all goes back to personal responsibility on netizens to check before making comments that can really hurt other people and their families.
Okay, thank you for that, Ms. Susanna. Okay, how about we move on to what existing laws and regulations that are employed to maintain public order and stability in light of this COVID-19 pandemic. For example, there have been reports of civil servants arrested under the Official Secrets Act for leaking COVID-related information. what do you think the swift action the ministries have taken in response to the leaks of this information have done to public confidence in our government institutions?
Okay, so obviously COVID-19 is a pandemic which threatens public health and safety. So COVID-19 related information to the public must be delivered sensitively. And if it is delivered recklessly, it has the potential to cause public alarm and can threaten social stability. So that's why leaks of such COVID-related information, they are taken very seriously. I think you've mentioned cases of civil servants caught under the Official Secrets Act, and I think these cases are ongoing. So you can imagine how news like that is going to create a public alarm. It is unprecedented, and it has the potential to change lives drastically. And the government's swift action and the way the government takes these cases seriously certainly helps to increase public confidence in how they handle COVID-19 as a whole.
Okay, so circling back to our previous point about social media, so I make reference to the specific case that of the leak of the joint media statement about the closing of schools and the moving to full home-based learning. I'm not sure about the account case. I just as of now, the only report is on the arrest of the offenders. But how do you think social media plays an impact about the leaks of this kind of information?
Yeah, I mean, with social media, the potential for public alarm it intensifies, right? Because I mean, if the leak is just by WhatsApp, WhatsApp goes to Facebook, Facebook goes to the rest of Singapore. So social media is the reason why swift action is needed, and that's just. I think the government response there is good.
Okay, thank you for that. I think I'm going to pass time to Ignatius to talk about other ways that the government has used pre-existing regulations or laws to bring about public order and stability.
Yeah, thanks, Brian. Yeah, Mr. I mean, you definitely mentioned kind of how social media magnifies the kind of capability of spreading wrong news very quickly. And I think that was one of the primary concerns in kind of instituting POFMA, the Protection of Online Falsehoods Act, which is quite recent.
Yeah.
I mean, it has been used numerous times during the pandemic through the issuing of correction directions. I mean, I believe one of the cases during the election, Paul Tambia was issued with a correction direction. And I'm just wondering about on kind of how a national crisis like the pandemic really illustrates the uses of such a legislative framework, particularly because of kind of how it has been. I mean, it has, as you say, online been criticized by maybe people who, or by sections of the public who don't necessarily understand its full ramifications and impact on society.
Yes. So you're right. You can certainly see the relevance of a law like POFMA more so in a pandemic. And I think you've highlighted the case of Professor Tambia. That's not the only case. Recently, the Straits Times also published some statements to say that the government was underreporting the numbers of COVID cases to minimize public panic, and the POFMA office issued a correction direction to state that the statements were false. And there are many other cases like this. So absolutely, POFMA is being actively used in this pandemic to curb the spread of alleged online falsehoods. But I suppose the issue that is being debated is that even though, yes, most people think it's relevant, to what extent can and should POFMA be exercised? POFMA, it was enacted to combat this internet phenomenon known as fake news. And the purpose of POFMA, if you go back to the purpose, it's to protect society because based on what we've seen overseas, online falsehoods have the potential to divide society and cause a lot of social unrest. So when you have a law like this, there's always a tension between balancing the need to protect the society from misinformation versus protecting free speech and open discourse. And sometimes the line is not so clear, which is why there are ongoing cases in the Singapore Court of Appeal, most recently involving the Online Citizen and the Singapore Democratic Party. And I think after this case, the court will certainly help us to shape the contours of POFMA and clarify the scope of its operation. But certainly with this, the reason why POFMA was even enacted in the first place was that recognition that the digital age, social media has the potential to bring fake news to a level that can cause public outcry. And we can see that we can see that relevance in the pandemic.
Yeah, for sure. I mean, I guess just as you pointed out, the courts are still kind of shaping how POFMA will be applied and like the scope of its application. I'm just wondering whether you thought there's kind of any difference in effectiveness of this kind of top-down correction, you know, kind of like from the judiciary as well as the executive arms of government, as opposed to, I think, more bottom-up verification of news that you were kind of alluding to, having the responsibility beyond the public to self-verify and self-correct, you know, kind of like one another, especially with social media where everybody is so kind of involved in the discussion, whether you think one is better than the other, especially in terms of optics, where I mean, suddenly many people have complained that POFMA is too heavy-handed and things like that. So I'm just wondering, hoping to get your thoughts on that.
Well, I mean, the law has already been enacted, and I think since it's already there, it can work. I mean, both can be utilized at the same time. I mean, put aside whether or not the scope of exercise of POFMA is correct. So let's assume, you know, things are done correctly and all that. That together with netizens exercising personal responsibility in posting their materials. If you put that together, that will really create a much better discourse in society. I think now that the law has already been enacted, both can work together very effectively.
Yeah, thanks for your perspective on that. Yeah, for sure. I mean, if both are kind of fulfilling a similar purpose, then kind of complementary use of both will definitely benefit Singapore greatly. I guess maybe in the interest of time, we'll move on to like one final question on more generally kind of how COVID has impacted criminal practice. I'm just wondering whether you see kind of any potential increase in crime due to kind of like the pandemic situation, and I mean how that pandemic has kind of impacted substantive crimes like new ways of scamming kind of coming up, you know, in COVID, especially by using false information. Yeah, your general thoughts on that.
So whether COVID-19 will cause an increase in crimes, I mean, I think there are two ways to look at it. COVID-19 resulting in financial hardship, causing people to commit more offenses to deal with that. And then the other way to look at it is the nature of offenses that are being conducted because of the COVID-19 situation. Actually, I think the police, SPF has released a statement recently to say that there had been an increase in the number of online scams, and that a lot of the crimes now, the nature of the crimes are being changed. There you see a lot more scammers and loan sharks trying to cash in on people's fears with scam tactics that are tied to the pandemic. So I think the changes that we talk about between COVID-19 and crime levels are twofold. On one hand, you may see an increase in the numbers of people who commit crimes due to financial hardship, and on the other hand, you see a change in the nature of the crimes, moving more towards the online or online crimes of an online nature rather than crimes of a physical nature.
Yeah, thanks for your insight on that. I guess really question which touched on crime will always be kind of multifaceted and kind of like just having a pandemic itself. I mean, that really it's really a more of a confluence of different factors that affects kind of crime trends. And actually on that note, we have actually come to the end of our interview. Brian and I would really like to take this opportunity to thank you again for dedicating your valuable time for this project. We hope everyone enjoys this discussion and everyone will kind of stay tuned to NUS Law's COVID for more conversations with lawyers. Thanks again, Ms. Susanna.
Thank you, Brian and Ignatius. It was a pleasure talking to both of you. Thank you very much for inviting me.